I think we are live now. I can see the participants part. The number is going up very quickly. So I'm going to give about 1 minute and then we can get it started. Okay, I think maybe we can start right now. Hi, everybody. My name is Leo Yu. I'm a member of the AYL's Judiciary Committee, and thank you everybody for joining us for this for today's CLE. And today's CLE, we're gonna have two judges from the county court and district court to helping us to young attorneys to understand the functionality of the court system of Texas. Before we started, I would like to introduce the two judges, but before that, I would like to have Ms. Harris from the AYL to say thank you for all the law firm to help us, that help us to have the CLE. Ms. Harris?
Hi, everyone, and thank you for joining us today. We were very fortunate to have a lot of law firms sponsor this series of programs that we have over the summer. I'd like to start by thanking our platinum level sponsors, which are Ackerman, Bell Nunley, Burke Bogdanowitz, Cobb Martinez Woodward, Ferguson Braswell Frazier Kubasta, Greenberg Trorig, Hartline Barger, Kane Russell Coleman and Logan, Castle Law, Lynn Pinker Hurst and Schwegman, Lyons and Simmons, Platt, Chima, and Richmond, Ryan Law Partners, and our gold sponsors are Aiken Gumstrass, Hauer and Feld, Carrington Coleman, Sloman and Blumenthal, Reese Marcados, Van Way, Presby, and Williams, and my dogs who are chewing toys in the background are not sponsoring this event. But thank you all so much for your sponsorship and for the attendees today for joining us.
Thank you, Ms. Harris. Today we have two judges with us. We have Judge Purdy from the 95th Civil District Court of Dallas. Before she took this bench, she was the Associate Judge of Dallas County, and before that, she was a Municipal Court Judge of the City of Dallas. Thank you for joining us, Judge Purdy.
Thank you for having me. Thank you for having me here.
And then we have Judge Bender. Judge Bender is a judge for the County Court at Law number 6 of Collin County, and he has been holding this position since 2010. And thank you for joining us, Judge Bender.
Good afternoon.
First question, I would like to direct the question to Judge Purdy. So Judge Purdy, you used to be an associate judge and now you're a district court judge. How about you explain the different roles of these two different courts, what the different duties and responsibilities and maybe jurisdiction differences?
Okay, yes, thank you. So for many years, since 2013, I served as a associate judge. Some people call it a magistrate judge in our civil district courts. Here in Dallas County, we mirror our federal system where we have our district court judges and we have 2 associate judges. So I think one of the primary differences between the associate judge and a district court judge is that the associate judge is not a court of record. And the primary reason behind that, the position was created by the government code. There is an appeal de novo back up to the district court. So I think that's something to remember. It's not a court of record, which typically means when matters are referred to me by the district court judge, a lot of times when people would show up for hearings, they would say, Judge, there's no court reporter here. And I say, you are correct, because I am not a court of record. I don't deny anyone an opportunity to have a hearing on the record, but we have to sort of arrange that in advance of the hearing. So for instance, if I happen to be sitting for the 298th on that particular day, and a party wanted a record of the proceeding, then I, of course, would contact the court reporter from the 298th and see if we could get some availability for her to come down to take the record. But the record really doesn't matter, because if a party disagrees with the decision reached by the associate judge, it's just going to be a de novo appeal. So there's not going to be any referring back to the record. You're essentially going to get a do-over. So I think that's one of the primary distinctions between the associate judge position and the district court position. Another thing is the associate judge position is an appointed position and not an elected position. We are appointed by 2/3 of the district court judges here. And you have to have that 2/3 to appoint, and you have to have the 2/3 to remove. So I think that's another distinction. The associate judge serves at the pleasure of the 13 district court judges sitting at the time, and an elected judge, of course, sits by the pleasure of the voters that elected he or her to that particular bench. So I would think that those are some of the main differences between the associate judge and the district court bench. Typically, the associate judge is not hearing anything of a dispositive nature because of that sort of de novo appeal back up to the district court. So I think that that is a little bit different. The associate judge is typically trying to assist whichever court it has been referred a matter from, and it tends to follow the guidelines of that particular court. When you become an elected judge, as I recently did on January 1st, I have more autonomy to kind of set things that I saw work in my old life and things that I saw didn't work so well. So I think you have a lot more autonomy when you become your own district judge. I sat for 7 of our 13 courts. And so that's challenging to get to know how 7 people run their courts and how they like to manage their dockets. But of course, when you are sitting in one court, you have the liberty to just manage your one docket. So that's
Now
all.
so now you're sitting on, you used to be sitting on the associate judge position. Now you're a district court judge. From the bench, do you think lawyers interact with the court rather differently when it comes to, associate judge and district court judge?
I don't think there's primarily any difference or anything. I think the lawyers are very good about respecting a judge, whether it be an associate judge or district court judge. So I haven't noticed anything in that particular regard. A lot of people, of course, that are appearing before me now, they have appeared before me as the associate judge. So they kind of know the things that I like and my style and just how I like argument to be given. But I haven't noticed a real big distinction.
Thank you. Judge Bender, let's talk about county courts. So I think for a lot of young attorneys who are, not really from Texas or went to law school in Texas, the existence of county courts sometimes just confuse them and they don't understand why we have a county court. They have district court, then you hear basically a lot of cases together. So tell us something about the difference between county court and district court and the jurisdictional difference, or, in practice, what is the major difference between these two courts?
Well, that's a great point. And I want to also start out by saying there is a difference between Dallas County and Collin County. Mm-hmm. So Dallas County, there are specific jurisdictions. We are general jurisdiction here in Collin County. So I have civil and I have criminal. Now, I do not have any family law jurisdiction, which is why I absolutely love to be the judge in this courtroom. But I think you, first off, as a young lawyer, you may be practicing in a county court and maybe a district court, but I think you have an absolute duty at a minimum to Google the jurisdiction of that court. Because I cannot tell you how many times I've had out of county lawyers show up filing a petition, and then all of a sudden they realize that, oh, well, unlike Tarrant County that has concurrent jurisdiction between the county courts and the district court, and therefore unlimited dollar values, we do have a jurisdictional dollar value limit. And so I think at a minimum, start out with, if I'm going to be in this court, where do I want to file? Because as the plaintiff, you get to choose what you want to file in county or district. And as a defendant, find out what the jurisdictional limits are of that court, because we are general jurisdiction. The other thing I want to point out, since it's probably focused on civil, is that in general jurisdiction courts, statutorily, your case is going to be placed behind certain types of crimes. Because inmate, assault, family violence, those statutorily have to come before those civil cases. So just be aware of that. I think that's a good starting point. So my jurisdictional limit on my civil side is capped at $250,000. And as of January 1st of this year, they're all expedited actions. Before, we had the 3 different levels of discovery, and now they're statutorily, they're all expedited. And the other thing you probably want to be aware of is that there is a difference between a constitutional county court and a statutory county court. I'm a statutory county court. We have 7 of them here in Collin County. You have to be a lawyer, all the same things that Judge Purdy was describing about the election process, having been a licensed lawyer in good standing with the bar for a minimum of 5 years to seek election. All those requirements are for statutory county courts, not so for constitutional county courts. So you may go to a rural area in a constitutional county court where that judge isn't even a licensed attorney. So just be aware of that.
Oh, wow. So for county court, do you want to talk about the difference between the jury system? And my understanding is in a county court, there are 6 spots in a jury box. And for district court, I think that's 12. Is that correct?
That's correct.
Mm-hmm.
So when you see a jury trial in front of 6 jurors, do you think lawyers usually think that is more, it's a little bit easier to handle, compared to a bigger jury pool?
It absolutely is. When you're talking about the voir dire process and you have a veneer, prior to taking the bench, being a practicing lawyer, you might have more than 100 people on your veneer that you're going to see 12 out of. Well, when you're looking at 6, I only bring in 25 veneer members. So that's 1/4 of the number of people that you have to sit there and question to get your 6, taking out of argument any sort of alternate jurors. We do have our pettit jurors 6, and so our veneer is smaller. You got a pettit jury of 12, you're gonna have a much larger veneer. Is it easier? Absolutely.
And I'll just add to that. I think it's probably depends on the strategy of your case and the type of case that you have. Of course, as Judge Bender mentioned, our county courts here, they seat 6 jurors and our district courts have 12. And if you have a really large medical malpractice case, you might want a larger veneer panel, and you might want to take your chances with 12 as opposed to 6. We have concurrent jurisdiction here with our county courts. So I think it's about strategy as to where you file, the type of case you have. I know when I was trying cases, not only is the type of case that you have, how quickly can you get to trial? Can I get to trial quicker in a county court than I can in a district court? It's going to depend on what their numbers look like. And then, of course, I think all those things matter. But I know when we were talking about how do we resume jury trials, there was a discussion as to, could we get parties to maybe try a case with fewer jurors because of the show rate with the pandemic going on. Most people that file in the district court, they are filing because they want 12 people to decide the fate of their particular case.
Judge Bender, let me ask you this. Do you think in Collin County cases are moving a bit quicker in county court system than the district court, or that's just a misconception of lawyers?
No, I don't think it's a misconception. I think that is the case. I mean, one, you have to understand that now, well, first off, our dollar, we're not concurrent. So my dollar jurisdictional limit is $250,000. So obviously you're not going to have a choice if you're seeking more than that. However, the vast majority of cases probably do fall within the jurisdictional limits of both the county court and the district court. As of January 1st of this year, we're now all expedited actions. And so, yes, absolutely. I've had the plaintiff's attorneys come and say, look, we're filing in county because we know we can get to trial quicker than we can in district. Because here in Collin County, the district courts have civil, they have criminal, but they also have family law jurisdiction. I don't have any family law jurisdiction, so that does assist us in getting cases to trial. Now, I do want to say with one caveat, there is no jurisdictional dollar limit on condemnation eminent domain cases. In Collin County property values, well, frankly, everywhere now, are exceedingly high. So there is no dollar jurisdictional, and statutorily, those have to come to county court. But if you have discretion, Judge Purdy's absolutely right. I mean, if you want to get to trial quicker, generally speaking, you're going to file in county court. But unlike Dallas County, you then also have to look at how much you're seeking in damages.
Correct.
Let's talk about another court that really usually doesn't get a lot of attention. That is a municipal court. I think for most people, municipal court, when they even think about it, the only thing they can think about is traffic tickets. That's where you handle your traffic tickets. But I work for the city attorney's office. I personally know that the jurisdiction of municipal court is much wider than that. But today we have an expert, Judge Purdy. How about you tell us something about municipal court and all those interesting little jurisdiction matters that people don't really talk about?
Yeah, well, something that I think young lawyers should keep in mind, or just many people that are on this webinar. I enjoyed my time as a municipal court judge. I think it is a great training ground in order to ascend to other benches. It is a court that has both civil and criminal jurisdiction. When you are a municipal court judge. So primarily when you say municipal, everyone thinks about that traffic ticket that they've received, or that running the red light and you got something in the mail telling you that you ran the red light and you're trying to remember where you were on that particular day. That's what typically comes to mind when you think of municipal court. But it is a very broad court that handles a lot of matters for the city that you sit in, especially, I'm only speaking as to Dallas. So there's a housing docket. Code enforcement works closely with the municipal court when they identify properties that have ordinance violations. It might be in need of being demolished. It might have a nuisance, things of that nature. There's a whole housing docket, or a property needs to be rehabbed. There's a whole housing docket dedicated to that. The other thing in municipal court, there's a juvenile docket that takes place just over juveniles. So that has some criminal jurisdiction aspects of it. Let's see, what else from the city of Dallas? There is an animal control docket. So and one of the good things I think about the municipal court system is, as a municipal court judge, I was never just sitting in one court. I was moving around to the different types of cases that I was hearing. And so I got exposed to all of those different dockets. There are community courts in the municipal courts, where actually the courts are located in the community. And the concept behind the community courts is to actually get people out of the ticket situation they might find themselves in. So it works with a lot of different resources and partnerships. And I have done dockets over at Lou Sterrett Jail. Essentially, when an offender might get picked up, and if they get booked into our jail here in Dallas County, they're going to run a check and see if you have any type of tickets for the city. And if you have any tickets for the city, speeding, warrants, you didn't show up to court. Well, the city court, we have a court located over there at Lou Sterrett. I understand they do it by video conference now. That wasn't during my time. I actually had to go over there and experience the people and the smells in the jail twice a day. But those are all the different types of cases that come to our city courts.
Yeah, I think one interesting thing about Texas is you actually see jury trials in municipal court, and
Correct.
I think that is quite unique. So, have you presided a bunch of jury trials in municipal court, and what is the difference between jury trial in municipal court and in other courts you've been presiding?
Well, I have presided over a lot of jury trials in our municipal courts for the city of Dallas, different types of cases. I think probably for those practitioners that might be on, to me, it's kind of like being over at our criminal court. The trials go very quickly. People are trying cases not just based upon I wasn't speeding, I wasn't parked here. You might see those types of cases, but you also are seeing the housing cases, the animal cruelty cases, and different things of that nature. But one of the things that I think is so enlightening about our municipal courts is that's probably the court that our public comes most in contact with. You are more likely to appear in a municipal court than you might appear in a county court or a district court. So I think you have some very, what do I want to say, very day-to-day type of jurors there. They understand, they've gotten tickets before, they might have gotten a citation for high weeds or different things of that nature, but things move very quickly in our municipal courts. It's very high volume. I remember doing dockets where I might get through 150 people that appeared on traffic tickets and then having 2 trials in the afternoon. So they go very quickly. People do show up for jury duty. They're eager to do so. And, I think it's a situation where the state doesn't always win, the city doesn't always win. So if you have a chance to show up for jury duty, if you get those summons over at the municipal court, I would encourage you to go and sit for a day.
Great. Judge Bender, do you have any experience in municipal court?
Well, keep in mind, I have appellate jurisdiction over municipal and justice of the peace.
Mhm.
So, and Judge Purdy explained, courts of record are important in de novo. So again, I just want to reiterate, if you appeal from those municipal courts or justice of the peace courts, it is de novo, you get a trial. But justice of the peace court doesn't have rules of evidence, right?
Mhm.
We do. So there's going to be a difference in the actual proceeding. We're going to have higher expectations of the parties than at JP, even though it's de novo. And I will also say with one exception, and that is if the lower court, or it's municipal court, well, we don't have any JP courts, our court of record, but if the lower court is a court of record, then you don't get a de novo. It is like an actual appeal where you file your appeal, you refer to the record, and I'm only making legal analysis, no factual analysis in that situation. So again, you have to know what your court is that you're in, what your appellate process is after that court. If it's a court of record, then it's not de novo. You don't get another shot at the apple in a trial. So again, preparedness is important. Understanding the jurisdictional limits of the court's important.
That brought a very important point that we're going to cover today. Is recently in the past year, really, we got a lot of eviction cases going on, and those cases usually start in JP court.
Yes.
And then my understanding is when they get appealed, it appeals to the county court in your court, Judge Bender.
Yes.
So can you tell us more about it? Have you received a lot of those cases being appealed to your court, and how court handle them?
Yes, so statutorily, they're required to start in justice of the peace. They have forcible detainer and actions as original jurisdiction, and I have the county courts at law have that as appellate jurisdiction. But again, it's a de novo. Did we have a lot of eviction cases? Yes, however, the government stepped in and stayed all those. The Supreme Court went in and stayed all those. So since the pandemic, because you got to keep in mind, the vast majority of eviction cases are for failure to pay. And rightfully so, understandably so, the legislative body and the Supreme Court stepped in and said, look, we're going to stay if eviction cases, if and only if it's a failure to pay. If it's a breach of contract some other way, whatever, there may be other issues, those can still proceed, but they were staying failure to pay eviction cases. So yes, we have seen a denouement in the number of evictions. Have I conducted them? Yes. I did one last week, but it's very rare, right? It's the exception rather than the norm right now.
Another question for those cases is, I know a lot of tenants who are in this eviction trouble when they back in JP court, it actually was not represented by anybody. They show up, per se. So when they come to your court, are they still per se, or usually they are helped by either nonprofit organization or legal aid? And are those cases well prepared to present to you?
So the question is, are the majority of eviction type appeals, even at this court, still self-represented litigants or pro se litigants? We do have legal aid. If they qualify, legal aid will absolutely step in and provide them counsel. But the vast majority of these individuals are pro se. Now, of course, us being county court at law, If you're a corporation, that's a legal entity, they had to be represented by counsel. So while they may have gotten away with being pro se at the apartment at the lower level of JP, here they're required to have attorneys. However, the law did change just last legislative session to allow property managers to come in and represent the legal entity of the apartment complex in lieu of them having to go get an attorney. I'm not going to speak to the legislative body or the legislative intent, but that is the one exception, the only exception that I'm aware of, where a separate entity is allowed to be represented by another individual who is not a licensed attorney. Has that been helpful to those people? No. The last time that happened, I had a property manager come in. I said, okay, we'll call your first witness. I don't have any witnesses. Well, do you have any evidence you want to present? I don't have any evidence, Judge. Well, that was an easy decision. But then now I'm having to deal with the motion for new trial with it. Now they hired an attorney. But yes, we do a lot with pro se litigants. Municipal court, I'm sure did, because I get a lot of those appeals. Most people are representing themselves at those lower level courts, and then they're kind of shocked when they come to county court and like, yeah, we're a court of record, and yeah, the laws and rules of evidence apply in this court. But that's absolutely correct. That's an astute observation, especially on eviction cases. If they had money to pay their rent, they would have money to hire an attorney. They would probably much rather pay their rent than have to spend that money on an attorney. So yes, a lot of self-represented litigants.
And I will
So-
also say that the district courts, we see a lot of self-represented litigants as it relates to property. So just as Judge Mender has mentioned, they have been at the JP court, they've appealed it up to the county court. County court has determined, who should have possession of the property. And then they come to the district court sort of as a last ditch effort to raise other issues that might not have been raised at county court. Maybe there's a break in the chain of title. Maybe there wasn't noticing that was proper. A lot of different things, but typically they are coming to the district court self-represented, and a lot of times coming to the associate court where I sat for many years trying to garner a TRO because the constable has put an eviction notice on the door, basically saying they have to be out by a particular day or they are going to forcibly remove them. Of course, this was, pre-pandemic, but I just wanted everyone to know on the webinar that we still see a lot of self-represented litigants in the district court, primarily when it's dealing with their property or their lease or their apartment.
Judge Purdy, that is an excellent point that I think needs clarification, right? We remember property law, first year law school, right? The bundle of sticks. Well, the one property interest that county court has exclusive appellate jurisdiction on is possessory interest. Anything else can go to district court, but possessory interest. And when we're talking about evictions, that's generally, somebody wants to possess their property back. But you're absolutely right. Thank you for pointing out, Judge. There may be other property interests that can be filed in district court, but not possessory interest. That statutorily under the Texas Property Code is vested in the county court of law.
And that is
Okay.
correct. And I have denied many of TROs that have tried to skip the county court and that whole possessory interest in property. But that is a good distinction to point out.
That's a great point too. I think we just made some very exclusive jurisdiction for the county court. I think young attorneys usually don't understand. So let's talk about the different atmospheres in different courts. So for me, I go to district court and municipal court a lot, and my experience is like in municipal court, lawyers tend to a lot more relaxed, but sometimes I feel like they're a little bit too relaxed, in my opinion. So Judge Purdy, so what kind of suggestions or advice you to give to young attorneys to go to different courts, to act a little bit differently, but not, too relaxed in a way?
Yeah, no, I definitely understand what you are saying there. The municipal court tends to be a little bit probably more relaxed. And I think, it goes back to just maybe your moot court days at law school or just your trial advocacy days in law school. I was always trained that a court is a court, no matter where you are appearing, whether or not that be a justice of the peace court, whether or not it be a municipal court, state court, or a federal court. So I've just always adopted and was trained in those types of classes that to err on the side of being formal is probably the best option. I know when I litigated in a lot of different counties. And as you can imagine, from county to county is different. We know from Collin County to Dallas County is different. But I think that if you are formal in your addressing of the court, that always puts the judge in a good posture. I think you have to dress like a lawyer, regardless if you're in municipal court and someone shows up in their work uniform. That's acceptable in municipal court for individuals to show up in it. We know they are working. We are trying to do our best to get them back to work. They are simply there to pay a ticket or to take care of their business. But I think a lawyer should look like a lawyer. And it shouldn't be hard for me to discern, are you here to pay your ticket or are you a lawyer with a client in this particular case? So I always just stress being formal, making sure that you are dressed professionally. Even if you are going to represent a client on a Friday afternoon for a traffic ticket, I still think it should require a suit and a tie, and it requires you to have some formality with the court.
Judge Linder, how about the county court versus district court? Do you think?
I completely concur with Judge Purdy. I think as an attorney, especially a young attorney, until you get to know that court, that specific judge in that courtroom, you should always err on the side of being more formal and then let the judge decide whether or not they want to be less formal with you. I think that's spot on. I completely concur with her assessment. And it doesn't matter if it's district court, county court at law, JP, municipal, a court's a court, federal court. A court is a court, and if you're an officer of that court, you should treat it appropriately. Now, if the judge of that courtroom decides that they want to have less formal proceedings, they will tell you. You always stand to make an objection unless that judge says, look, you don't have to stand anymore. But no, you always start out more formal, and then you wait for that particular court, that particular judge to change things. But other than that, there's a reason why we do that training in law school. And I'll also share this with the young lawyers. When I was in law school, I'm sure everybody else was the same way. 1L, you're getting called on, and you're having to stand up like, oh my God, why do I have to stand up? I can answer this question sitting down just as well, maybe even better than if I'm standing. But I would tell you from my standpoint now, having been on the bench a little over 11 years now, it's important because I have 2,000 plus criminal cases. I have 1,500 civil cases, things going on, and I get my attention drawn to other places. And somebody makes an objection, I don't know who just spoke. So I can immediately clue in on who's standing up, listen to them, and make an appropriate ruling and move on. So it is important, I assure you, from my standpoint, the court standpoint, standing up to make those objections is absolutely imperative. And there's a reason why they start training you from day one to be a lawyer to do it. You just don't recognize it because you haven't been on this side on the bench, but it's very important. So I completely concur with Judge Purdy.
Thank you. Let's talk about the briefs. I think for most young attorneys, when you get to the job, I think your first couple of really a year or so usually is to write brief to the court. And we had multiple CLEs to educate young attorneys, things to follow, or we really started this education since law school. But in practice, I want you to tell young attorneys one or two things you just don't tolerate. Those one or two things you look at them, it just immediately trigger you and you don't want to deal with it. And let's hear that. Judge Purdy.
I can't hear Judge Purdy. Is my mic working?
Sorry about that. Can you hear me now?
Yes.
I was just asking for, in terms of briefing, are you asking the question of things that we can't tolerate or just sort of just quirky things in court that we can't tolerate? I just wanted
either way, something that really triggers you, like, I don't want to hear this, I don't want to see this on paper.
Well, one of the things here in Dallas County that I think a lot of the district court judges spend a lot of time on and expect lawyers to do is to really adhere to our local rules. So I think that probably nothing bugs me more when it is apparent that attorneys have not conferred before they are setting their motions with the court. Again, I'm going to sort of look back at my days as an associate judge where I sat over lots and lots of discovery disputes. And, discovery disputes, they're detailed, they're long, they take up a lot of time. It takes up a lot of prep time for the court to kind of understand your case and understand the type of discovery that's being sought. So nothing kind of probably bugged me more when I had prepared for a hearing. I have both parties to show up. It's a motion to compel. I'm being told that, Your Honor, we conferenced, they did not respond to these interrogatories, or they had objections to these requests for production. And the other lawyer will respond, we'll withdraw, we'll have what they need today by 5. And, that's not you didn't conference, that didn't just happen before you came in. And I think that's just, we are under such time constraints as a judge that, I guess if you're at a law firm, you have a lot of different people that handle different aspects of maybe that motion to compel. But on this side, it's only one of me handling that. So I appreciate people that call me the night before or leave a message or send an email. Hey, Judge, we pulled down our particular motion. We're not going to go forward. We are working through it. I'm ready to have that motion and that fight when you want to have it. But it just bugs me when parties can't confer and really streamline the issues that they need to fight about for the court. So that's probably my least tolerable thing on the bench.
Yeah, just a quick reminder for young attorneys who practice in Dallas County is it is mandatory to confer with your opposing counsel before you file a motion in a state court in this jurisdiction. And it's actually, the local rule has a very specific format for that certificate you have to follow. Otherwise, some judges will just deny your motion. So Judge Bender, what is your opinion on that?
I would tell you our bar is good. I really don't have anything that sets me off. But I will share this one thing, because I know that I'm representing the county court and Judge Purdy's representing the district court. But I do want to caution the attendees that the district court here in Collin County has very strict time limitations of 20 minutes per side. And that's 20 minutes total. It's putting on yours, cross-examining, whatever it is. And they're very stern about it. So I want to make sure that, just to caution you, while you may think, okay, well, I'm going to go in there and I'm going to pontificate on everything under the sun, you're not going to get to in district court in Collin County. You're going to be given, they'll put a time limit up on the screen and they'll have a timer there. And 20 minutes is 20 minutes. So that's your opening, that's your direct, that's your cross, that's everything. So just be aware of that. But honestly, I haven't come across anything in 11 plus years I've been on the bench that's really just set me off, because the bar does a great job. They're officers of the court. They're trying to be respectful because their time's valuable, just like the courts. And I haven't really had anything, I'll be honest with you. Nothing really sets me off.
Well,
but you go through life looking like this, what are you going to do?
Good for those attorneys in Collin County. They must have done a very good job, I assume. So a lot of young attorneys, when they even are allowed to go to court by their partner, they usually put as a second chair. So my question is, how to become a good second chair attorney? What is your advice for young attorneys?
My advice would be, whenever I have served as that second chair, your first chair, they're relying on you to know the case just as well as they know the case, know where those documents are located. You are there to, help them in their particular argument. So if a question is being, asked of a particular first chair lawyer and your second chair, and I don't think you really answered the question that the judge has asked you, I'm going to get that yellow sticky note, write my little question, slide it over to you so that you can see it, and, many times they'll tell you, oh, good point. I left that out. I'll get that to next time, those kind of things. But I think the second chair has to be just as well versed as that first chair lawyer does. You have to know where those documents are located, know that case, listen to everything that is going on, write those notes to your first chair. And a lot of times, your first chair, after they have some comfort level with you, I know at least that happened to me, they would give me different parts of the argument to handle. They might take 2 particular points, but they would ask me to handle 1 particular point. And I think that's a good way in which to do that, and a good way for that person to build trust and rely upon you.
Judge Bender?
I would break it out to two different areas. It depends what you're sitting second chair for. If you're sitting second chair during voir dire, I think your goal is to sit there and pay attention to the venire members that your co-counsel is not able to focus on, because you're going to get biofeedback. Now, you're probably not going to raise enough issues just out of that alone for a Batson challenge. But the reality of it is, you're going to pay attention to those individuals that your co-counsel cannot. And that way, when you go back to strike your list, you can make an informed decision about your strikes. So it depends on what process you're doing in the courtroom. So if it's during voir dire, you're absolutely paying attention to everybody else other than the one that your co-counsel is focused on, because they can take care of that one. And look at body language. Sometimes people miss hands. Who agrees with this person? Somebody might miss a hand. It might be very important. Could lead to a challenge for cause that you just lost, and now you're having to use a peremptory. So that's one aspect, voir dire versus everything else. Everything else, I say, to be a good second chair, I agree with Judge Purdy 100%, but to the next level is pay attention to why the lead is asking those questions. What questions are they asking? Who are they asking those questions of? Because you also need to take care of yourself and grow from that moment, because at some point you will be the first chair. At some point you will be the ones responsible for those questions. And understanding that process is why you're there. There's a reason why you're the second chair instead of the primary. You're there to learn. So take advantage of that. Be helpful. I agree absolutely with Judge Purdy, but also take advantage of it and learn, because there's a reason why they're first chair. They are definitely quality counsel. And the reason why you're there is to learn from them. So that would be my second piece of advice.
Thank you. And I definitely would like to concur with Judge Purdy about you just have to be as prepared as your first chair, because you don't really know what's going to happen in the hearing. I have some experience on my own that I was the second chair and the first chair was supposed to argue everything. And it was the case in Dallas, a court in Dallas District Court. I'm not going to name the judge, but what happened is the first chair and the judge didn't really click. And the judge was really frustrated because the judge believed he was not getting the answer he was asking. And the judge turned to me and asked me to do everything from beginning to the end. And I was so glad that I was prepared on that day. Otherwise, I don't want to be the person who stood up and said, Your Honor, sorry, I was not prepared. I cannot do this. So, yeah. Another question is about, I got questions from young attorneys asking this, is that, I am actually, when we are, say, doing a summary judgment, I'm actually the person who did everything, and I gather the evidence, make the exhibit, I made all the argument, I wrote the brief, but I was not the person who actually get to go to court and actually argue that. And I think there are several judges that I know of have made that a local, not a local rule, but a chamber rule, that if the young attorney is the attorney who wrote the brief, the attorney needs to go to the court. I believe that's what Judge Boyle is doing right now in federal court. So what is your opinion on that? What is your position on giving young attorneys more, airtime, to a courtroom?
I think that's a very good policy to have. I think here in our federal court here in the Northern District, I think Judge Lynn has spoken to that particular issue, our chief judge in the federal court, that she wants to give younger attorneys more opportunity to argue things in federal court, which normally never happens over in federal court. So I think it is a good policy to have, because I think a lot of times when you are at a big firm, you just simply don't get to do that. What I can tell you is that in the pandemic, when we first started the pandemic and we went to a lot of Zoom virtual hearings, the only people I saw on my virtual hearings were not those big partner law, they were the young lawyers. And that was because I kind of surmised that the older lawyers or more senior lawyers weren't really comfortable with the technology. I think now that we've been in it for well over a year, they've had to find some comfort level. But I can't tell you how many hearings I logged on from my dining room because I wasn't coming into the courthouse. And it was a young lawyer from a big firm, And they did a great job in making that virtual hearing PowerPoint presentation, sharing the screen, just all the things that are sort of in their wheelhouse anyway. And I think a lot of them thrived at the beginning of this pandemic. And I think a lot of the senior lawyers are noticing we have to have their involvement or participation. A lot of our things may stay in a virtual format. But it is so hard for someone, and I don't know if I'm sure Judge Bender feels the same. You know, the other day I was on Zoom from 9 until 5:30 with like 1 hour break for lunch. And it is very hard to be in those hearings where you're just listening to argument. For me, someone that's visual, that can look at a shared screen, can see it side by side, all those kind of things help. And so I think some of the younger lawyers, you should take advantage of where we are right now in technology, take advantage of some of this virtual format, because I think that's going to open the door to get you a lot of more participation, maybe at some of these bigger firms for things that were traditionally off hands for younger lawyers. So I'll just add that, but that's sort of my takeaway.
Judge Bender.
Again, I agree with everything Judge Purdy's saying. I will say, though, that one of the changes that we judges collectively agreed on here at the county court at law level in Collin County during the pandemic environment was to just have them via submission, because we were limited in what we could do anyway. And so that hasn't really impacted us from that standpoint. But it would also just, if you're having a hearing on an MSJ, I guess we're specifically talking about MSJs, it just kind of commonsensically speaks that the person who wrote the brief is probably going to be the one most intimately familiar with everything and be able to put your best foot forward. So you're putting yourself in the greatest possible position to succeed by having the person who wrote the brief making the arguments and answering the judge's questions. So it kind of behooves the firms to send in the person that wrote it to begin with. I mean, you think that it would be in their best interest. That's just my opinion.
Another thing I just wanted to add is, I think Judge Purdy brought a very good point is, you know, if you are a young attorney in your firm, you're automatically the technology expert. It doesn't matter if you were a computer science major or not, you are. And your partner probably going to ask you a bunch of questions about how to conduct Zoom, what is the difference between Zoom and other forum, and you need to be ready, and you need to be able to do all the share screens or on mute. That's going to be your job. Just be ready for that.
Yeah, and to just sort of expand on that a little bit, I participated in a first all virtual jury trial. At that time, I was still the associate judge, and I sort of sat second chair with Judge Hoffman. We had 2 judges on that particular virtual trial. It was a motor vehicle accident case. It only took the 1 day to try it, 1.5 days in which to try it. But, you know, Judge Hoffman is always known for having a lot of interns. And literally we were, you know, asking the interns, how can we do this? How can we get this on here? How can we do this? And, you know, they're giving us ideas as to how to do that. Again, this is their wheelhouse. This is where they thrive. I think sharing those ideas and just collaborating is going to make you more valuable.
So when you, you know, look at a young attorney who obviously very new to your court, and you can just tell that's probably one, you know, his or her very first several hearings. So what is the usual mistakes you usually see from young attorneys, and what kind of advice you can give to them? You know, I can speak from my experiences, because one of my very first hearing was actually in Judge Purdy's court.
Was
And one
it?
thing, yeah, one thing you told me at the very beginning is like, counsel, you're speaking way too fast. I need you to slow down, which is a really good advice, and I've been following since, you know, since then. So what is your advice to attorneys who just started to go into court to argue motions on their own?
Sorry about that. My sound cut out again. Well, I didn't recall that was your first hearing. I was probably just trying to make sure my court reporter could get everything down if she was there. But you know, I will have people tell me after they had the hearing, you know, Judge, this was my very first hearing before you. Is there anything different that I could have done? And I may give them, you know, some tips in that particular respect. But I think you just have to know, you know, the court that you're coming before. So for instance, associate judge court. That's where I was sitting. I sit for 7 of the 13 courts. I probably have matters set like every 30 minutes. I don't have a lot of time. I know we talked a little bit about briefing. I think one of the biggest things as a young lawyer, making that transition from law school to a young lawyer, I think in law school, I thought I just had to write, and volume was everything in law school, and footnotes, things of that nature, and research and cases. But then what was hard once I became a lawyer was they didn't really want the volume. They wanted it, kind of to the point. Brevity was best. So learning how to rewrite in that particular instance, it took a while to get there. So I think young lawyers have to focus on that. I know for me, the court that I sit in now, with the pandemic, we've amended our local rules. We're asking individuals that file paperwork to not exceed 25 pages. Say what you have to say in those 25 pages, just because there might be instances where we can't get to the courthouse. So I think maybe I went to a CLE myself, and I had maybe a judge, say a federal judge, and basically her rule of thumb was if you couldn't say it in the first 5 pages, you must not be able to say it at all. So it must be hidden, and you must just be going to conjecture. And I sort of agree with that from everything that I've read. I think you have to hit it the hardest with your first 5 pages and give your very best arguments and persuasive and to the point, because we just can't get through all of the volume. So, learn how to do that, learn how to be brief. I think you have to know the court that you're in, know the audience that you're there. But that would just be my advice to young lawyers, to always err on that side of being formal with the judge, as brief as you can, and everything else that you've learned.
I remember Judge Parker said something similar, like she said, there's literally nothing that you cannot explain in 20 pages. There's nothing like that. There's nothing in the legal world that we just cannot do in 20 pages. Judge Bender, what is your opinion on that?
I concur. One thing I will touch upon, and something that you mentioned, is speed, but also clarity. When you get on the record, when you're formally on the record and you're speaking on that record, everything is being taken down. It's all in the record. You're not even consciously doing it. You probably don't even think that you're doing it. You're probably not even aware of it. But when you get that record back and you're reading through it, I assure you're going to look at it and it's going to be in there. It's all on the record. So just when you're speaking on the record, be as concise and as clear as possible. And if you have a habit, unintentional, of using ums or uhs or pauses because you're thinking, but you're communicating it while you're thinking, whatever's coming out of your mouth is going right into that record. So just be aware of that. The other thing is a little off topic, but it was some sage advice that I was given when I was a young lawyer by a district judge who's now retired down in Dallas, Keith Dean. And he called it the 40-year rule. And I will share it with the panel and also the members that are watching, because it was sage advice. And he said, it's the 40-year rule, Jay. He says, you're going to be practicing law around here for the next 40 years. And you might be able to squeak out a good reputation during that time. But I assure you, you screw one thing up one time, you'll forever have a bad reputation. And that was pretty sage advice. How is that lawyer's creed? We always take it for advantage. Honestly, I think we take it for advantage. We really should take it to heart. And how you treat opposing counsel, how you treat your co-counsel, makes a big difference. We are a profession. We see each other every day, day in, day out. And that reputation is going to be earned one way or another, and it'll be deserved one way or another. So he called it the 40-year rule, so I will pass that on. 40-year rule.
I got a question from our audience, and the question is, do you have any suggestions or advice to the situation where your opposing party is pro se? I think the question is more about what level of attorney are you turn on at. You don't want to turn on as like a full-blown attorney trying to almost bully the other party who does have money to hire an attorney. So what is your suggestion or advice on that?
From someone that dealt a lot with pro ses in our magistrate court, I would much prefer for them to be represented by counsel than to represent themselves. But obviously, I understand life's challenges and that everyone is not able to find a lawyer. I, of course, would let them know of every resource that I learned about as to how to get them some type of representation, because I think you're at a disadvantage if you start off representing yourself. There are lots of rules that you have to know the command of, evidence that you have to know the command of, and many times I see lawyers don't have a command of all of these things. So I encourage people to, if they have a claim that they want to protect legally and that they think is valid and that they would like to pursue, that they find a lawyer in which to do that. But I think when you're interacting with a pro se, I have always sort of taken the opinion. I did a lot of work for a tax law firm, and we collected delinquent revenues on behalf of governmental entities. So as you can imagine, a lot of times people were not going to go get a lawyer because I owe property taxes. And I just treated them with respect, let them know. Of course, there were very few defenses that you can offer to a property tax lawsuit. So I didn't feel like I was stepping across the line. Either you had paid the taxes or you don't own the property, but you could not have these disputes about, well, the property is valued too high. There were certain things that you had to do before now in order to complain about the value. But I would treat them with respect, let them know what I'm trying to do. A lot of times I think you might be dealing with a pro se litigant, maybe if it's a debt collection case. So a lot of times people are unable to pay their credit cards. American Express will sue you if you breach the agreement with them, and they will sue you in our district courts based upon maybe the amount of money that is at issue. And a lot of times, if you treat those individuals with respect, let them know, my client is going to urge this judgment against you, but if you want to enter into a payment plan, make some type of arrangements, I can put you in touch with the people in which to do so. So I think you have to have some empathy, but you still cannot make sure that you are not giving up any type of duties that you owe to your actual client.
Judge Bender?
Yeah, I think that last point is exactly right. You owe a duty to your client, not the opposing side. Now, that doesn't mean you have to be mean. I absolutely treat them with respect. But I would tell you in my courtroom, and I think generally speaking, the judiciary as a whole across the state of Texas wants to treat pro ses with kids' gloves because there is already a kind of an unlevel playing field. But I explained to the pro se litigants in my courtroom that the rules apply equally to both parties. And simply because the other person is schooled in those rules because they've taken the time to do that, doesn't mean that the rules change for the other party. I don't help either side. And so I want them to understand that, because I think that usually encourages them to go hire counsel, frankly, because if they don't think that they're going to get help by the court, and I tell them flat out, it would be patently unfair for any court to help either side, either way, or to change the rules. As long as the rules apply equally to both sides, then it's a fair system. So I try to encourage them that way, but just be respectful, but also realize, just as Judge Purdy said, your duty is to your client. You can't give, and you're going to be tempted to help them out, maybe give them what we would consider legal advice because you have this knowledge and you know it. Don't do it, because then you're going to put yourself in peril potentially, because they're going to go in and say, well, Judge, they told me this. That's going to leave you in a lurch. So you might be tempted to do that. That empathy, that sympathy, it's totally understandable. We're humans, right? That's the counselor portion of our attorney and counselor at law license that we have. But make sure you never cross that line. Just treat them with respect, but you have a duty to your client. That's all.
Thank you. 1 hour is almost 1 hour right now, and thank you very much for our two judges here today, spending some time with explaining the different functionalities of different courts in Texas, and also give out a lot of really good and valuable advice to young attorneys. And thank you again, and thank you everybody who participated in the CLE. And the CLE number, which is in the chat, is 174-124-974. And also thank you all the law firm that helped us to put this together. See you next time.
All right. Thank you.
Thank
Have a
you.
good
Thank
day.
you, everybody.
Bye-bye.
Y'all take care. Judge Purdy, it's good to see you.
Good to see you. Take care.